Hi everybody, Shariq, regulated Canadian immigration consultant. So there seems to be a lot of confusion about who qualifies as a dependent child if the parent is applying for a Canadian immigration stream, be it permanent residence or temporary residence, such as study permit or work permit. So in this video, we'll look at some details regarding that. So first of all, who qualifies as a dependent child? So there are two major requirements. Number one is based on age. If you have a child or if you have children who have not attained the age of 22 or less than that, they're considered as dependent child. At the same time, they should not have a spouse or a common law partner, meaning by they should not be in a marital relationship. If these two conditions are met, they are defined and considered and accepted by Canadian immigration as a dependent child. Now there is an exception for this age requirement. Children who have a mental or a physical handicap or a condition because of which they can't live their life independently, and even before the age of 22, they have depended on the parents, on the applicant, for financial needs. Such a child, even if the age is above 22, will be considered as a dependent child. I'll repeat, they need to have a mental or a physical condition which because of which they cannot live their life independently, and even before the age of 22, they depended on their parents for financial needs. Next question that a lot of people ask as to for which applications dependent child can be included. So all Canadian immigration applications, if your child meets the requirements that I've mentioned already, they can be included as a dependent child. So this can be a permanent residence application by a federal program, by a provincial nomination program. If you're applying for a work permit or if you're applying for a study permit, even in that cases, if they meet these requirements, they can be part of your application as a dependent child. Then there is the question as to what is the date on which this age is calculated. So technically, this is called the lock-in date, the age lock-in date. If you're submitting your application to Canadian Immigration, IRCC, the federal department, the date that your complete application was received by IRCC is the lock-in date. So I'll give you an example. Say for instance, you submitted an application on 1st of January, and it was, say, a permanent residence application, and at that time your child was 21 years and 10 months. Now it took IRCC 2 years to process that application. So your child in that time has moved on to be close to about 23, 24 years of age. The lock-in date will be when your application was received by IRCC. Similar if it is a different application. In some instances, to submit an application to IRCC, you have to do a process before that. This is pretty common if you are applying for a provincial nomination. So and even more common for the investor or entrepreneur streams, where you submit your application and they take a lot of time. So you will only submit your application to IRCC for PR once your application has been approved by the province. So in such an instance, the lock-in age for your child will be taken from the date that your complete application was received by the provincial authority or the process that was required before the IRCC processing. Just giving an example, you applied for say British Columbia's or Ontario's business investment stream, entrepreneur stream, and it took and it can take like a year, or in some instances even more, and then you apply for your permanent residence application once your PNP application is approved. So the lock-in date for the age of your dependent child or children will be when your application was received by the province for the PNP assessment. One thing that I'd like to add over here is that if you are submitting a temporary residence application, like a work permit or a study permit, and you have a dependent child, you are required to, as part of your complete application package, a separate temporary resident application for them as well. So depending on what age they are, they may be required a study permit, or they may require a work permit. Whatever the case be, as part of your application, you have to submit that. It is going to be your application which will be assessed as the main application. And if assessment is done on your application and it seems fine, and your dependent child is admissible otherwise, then they will be granted. It's not that they will be looked at based on their own application. So the main application will be yours, but yes, admissibility and other factors will be looked at. So you have to submit an application alongside your application for your dependent child if you're applying for a temporary residence visa.